Good morning. My name is Barry Penner. I'm the Managing Director of the Canadian International Internet Dispute Resolution Centre. Welcoming you to our webinar today. We have a number of distinguished panelists for this discussion, and we're looking forward to today's topics. First, I'd like to just put up a slide and tell you a little bit about the CII-DRC, the Canadian International Internet Dispute Resolution Centre. We were established in 2019. Although our parent organization, now known as the Vancouver International Arbitration Centre, has been doing domain name disputes since 2002 for the Canadian Internet Registration Authority for .ca cases. You can see that on the slide there on the left. That's the flow pattern you'll find if you go to our website. And if you're dealing with a .ca dispute or a case, that will provide you the information you need to either respond to or initiate a complaint. More recently, in 2019, we started handling cases for ICANN, the International Corporation for Assignment of Names and Numbers, for UDRP cases, Uniform Dispute Resolution Policy. And again, through our website, you can access that option for handling cases or initiating disputes involving those policies or that policy. So we're the newest service provider for ICANN on the block. We're the only one in Canada authorized by ICANN to handle such disputes, and the sixth in the world, and only the second in the Western Hemisphere. So we are the new kid on the block, but that means that we try harder, and we work very hard to provide good service and timely responses. With that, I'd like to now go to today's agenda and talk about our panelists. There's the agenda. We will have three people joining us, all very experienced and with considerable depth in the subject matter. In no particular order, I'll introduce Daniel Anthony from Smart & Biggar will be speaking to us. He has 15 years experience as a litigator and is known as one of Canada's leading experts in intellectual property issues relating to the internet, social media, and domain names. He has appeared as counsel before the Federal Court of Appeal and the Ontario Superior Court. He handles clearance, prosecution, and registration of hundreds of trademarks, and has represented clients in the trademark opposition and cancellation proceedings before the Trademark Office. Daniel is regularly called on as a speaker within the profession and has been interviewed as a legal expert by the media, both for radio and in print. Daniel is a contributor and editor of IP Update Canada, the law firm's intellectual property law bulletin. It's also my pleasure to introduce Georgina Danzig. She's with Here Law. She is also an experienced litigator, acted before the federal courts and the Superior Court of Ontario. She has years of experience dealing with complex litigation and extraordinary remedies. Georgina is recognized globally as a thought leader on anti-counterfeiting legislation, policy, and practice, and wrote the Guide on Canadian Intellectual Property for European Businesses for the European Union Comprehensive Economic and Trade Agreement Market Access Program. Georgina has been ranked as one of Canada's top 3 anti-counterfeiting lawyers by World Trademark Review 1000 in their 2022 guide. And last but not least, I'd like to introduce James Plotkin. James is a bilingual litigation and disputes lawyer in Gowling WLG's office in Ottawa, practicing in the advocacy and intellectual property groups. His practice focuses primarily on commercial litigation and arbitration, both international and domestic, along with intellectual property litigation and administrative law. James has appeared before the Supreme Court of Canada, the Federal Court of Appeal, and the Federal Court, as well as all levels of court in Ontario. He also frequently acts in international and domestic arbitrations. James is certified as a qualified arbitrator by the ADR Institute of Canada and is on our expedited procedure arbitrator roster for VANIAC and is available to arbitrate commercial and intellectual property related disputes. James is involved in domain name dispute resolution, both as counsel and as adjudicator. So that's the people that you're going to, those are the people you're going to have the benefit of listening to. And we hope you'll find this productive. If you have questions, please indicate that by posting your question in the chat function or the question function that's available through the Zoom program. And we will either answer those as we go if they're relevant to what's being discussed at the moment, or save that to the end of that topic and bring those questions forward. So with that, and without any further ado, I'd like to turn it over to our first topic. And who wants to take the lead on this? Will that be you, James?
I'm happy to take the lead.
I think Georgina's going to lead us off.
Okay, great.
Thanks, Barry. Thank you very much. So I'm going to start. We have a lot of topics to cover. It's going to be a little bit of a rapid fire, but I think it's important because we have such a breadth of participants on the webinar that we try to address the different levels of, I guess, experience coming into today's session. So I always think it's important to start a little bit at the beginning. So I'm going to give you a very, very quick overview of the lay of the land before we get into the weeds on this very first topic. As I'm sure most of you know, a winning claim under the UDRP and the CDRP requires that the complainant meet a three-pronged test, which establishes three elements: that the offending domain name is identical or confusingly similar to the complainant's mark, that the registrant has no rights or legitimate interest in the domain name, and that the domain name was registered and then in UDRP context and is being used in bad faith. But before you can get there, you need standing to file your complaint. And one of the key differences between the UDRP and the CIRA domain name dispute resolution policy is that CIRA imposes a Canadian presence requirement as a condition precedent to establishing eligibility to be a complainant. So what is the Canadian presence requirement, or the acronym we use is CPR? Section 1.4 of the policy requires that in order to initiate the complainant at the time of the initiation of the complaint must satisfy the Canadian presence requirements for registrants in respect of the domain name that is the subject of the complaint. And then section 2 of the CPR lists all the different types of individuals and entities that are permitted to apply for registration of and to hold on to and maintain the registration of a .ca domain name. So the list at section 2 enumerates about 15 or so different types of persons, each of whom the policy has determined has a sufficient connection to Canada to meet the test. So if you're a Canadian citizen or a permanent resident, if you're a corporation, a partnership, a trust, an association, or a trade union that exists under the laws of Canada or our provinces. And then there's some additional listed entities and legal constructs, each of which have a defined connection to Canada. However, what's not on the list is a foreign complainant. And so foreign complainants, a company registered in the United States, a citizen of Germany, a foreign complainant who does not meet the 15 or so of the above listed Canadian presence requirements for registration may still, according to our rules and policy, be granted standing to bring a complaint based on their rights as a trademark owner. So section 2Q of those list of criteria provides that a foreign complainant that owns a registered Canadian trademark, not a common law mark, but a registered Canadian trademark, may be eligible to advance a .ca complaint, provided the complaint concerns a registrant using, and I'm quoting here because I think it's important, the exact word component of the complainant's registered trademark. So that language, the exact word component of the complainant's registered trademark, you will note is quite different from the first element of the test, which is broader, which is an offending domain is identical or confusingly similar to the complainant's mark. For this purpose, it has to be an exact word component of the complainant's registered trademark. So if that's the case, does it mean that there is no protection, by way of example, afforded under the CDRP to a foreign complainant who owns a registered trademark in Canada against, for example, typo squatting of its registered Canadian trademark, but that there is protection for a resident who holds, let's say, an identical Canadian registered trademark in the identical circumstances. And it appears that that very issue has been tested and considered before the panel. And the case I want to refer you to that answers the question is a case called, it's a Skechers.ca case. It was decided in 2020. My fellow panelist, Daniel Anthony, was the counsel for the complainant in that case. And in that case, the complainant owned the trademark Skechers, Skechers, and the complainant is a US company, so a foreign company, but it held a registered Canadian trademark in the word mark Skechers, amongst others, Skechers. But the registrant was not only using the identical Skechers mark, it was also using Skechers with a T, Sketchers. And the panel concluded that with respect to the exact reference to Skechers, it was obvious that the domain name consisted of the exact word component, and determined that the complainant therefore had satisfied the standing provisions or the CPR provisions. But with respect to the domain name Skechers with a T, Cher, because the complainant did not have a registered trademark for that exact mark, they were not able to meet the Canadian presence requirement. So, I mean, I'd love to hear from Daniel on that, but I know we're going to hear from James as well, because it seems to me that that provides some limitations for foreign complainants who do have registered trademarks in Canada. And so my understanding is that there are a variety of commercial workarounds that have addressed these issues, some of which have been tested, others perhaps not. And I now want to turn it over to James to provide us with some guidance on some of these workarounds or alternatives to address this limitation in the proceedings.
Thanks, Georgina. Before I get to, so there are a couple of cases I wanted to speak to in particular where you have a foreign complainant who's trying to rely on common law rights, either because they don't have a registered trademark or because the registered trademark post dates the domain name registration, which would cause you to fail under the first prong of the analysis. But, you know, I was kicking around this idea of whether in fact the policy requires to be an eligible complainant that you have to have a trademark that is identical to the domain name. And if you look at 1.4 of the policy entitled eligible complainants, it says the person initiating the proceeding, the complainant, must at the time of submitting the complaint satisfy the CPR in respect to the domain name that is subject to the proceeding. And this is the important part, unless the complaint relates to a trademark registration in the Canadian Intellectual Property Office and the complainant is the owner of the trademark. So to my mind, that means that if you have a trademark that is not identical, you can still sustain standing as a complainant. The issue is whether you can get a transfer remedy, because in order to have the domain name transferred to the complainant, you have to meet the CPR, because otherwise you can't hold the domain name. So one of the workarounds that you alluded to, Georgina, was the possibility of, you know, setting up a Canadian entity to hold the domain name after you have it canceled in the proceeding. So the foreign complainant uses a Canadian trademark registration to kick out a typo squatting instance of cyber squatting, and you then so you don't get it transferred because you wouldn't be eligible for that remedy, but you have it canceled, and then immediately pick it up with the new Canadian entity. Now, I've never seen that done in practice. I've never seen a decision on this point. So, you know, if your panelist rejects the the argument that I just put forward, don't hold it against me, even if that panelist is me. But I think that that's something to be considered. Now, as far as whether you can use common law rights that were established before the domain name was registered, but were in the hands of a foreign entity, there's actually divergent cases on this. And so in 2011, there's a case called Air France KLM v ML Group. And in that instance, there were two complainants. The main one was an amalgamation of Air France and KLM after those companies had merged, but the second complainant was KLM, the Dutch entity that had the rights, common law rights dating back to, according to the evidence, 1949 in Canada. And so what happened there is there was a trademark registration for KLM, but it post-dated the domain name registration. And so the panel found it was sufficient to establish standing under the CPR because the registration was identical to the domain name, but it couldn't be used to further the complaint because it would have failed at the first limb of the test, namely confusingly similar in respect of a trademark or a mark rather, in which the complainant had rights predating the registration. And so what happened in that case, the panel found that the complaint was still eligible and allowed it to succeed on the basis of the common law rights, which were transferred from KLM, the predecessor entity, to the successor entity, KLM Air France. And the tribunal in that case, or the panel, I should say, wasn't bothered by the fact that the assignment post-dated the domain name registration. And so that's one point in the ledger, on the side of the ledger for complainants. A couple of years later, there was a 3-member panel decision in a case called ASOS Canada Services and Nexon Media Inc. And in that case, the facts were slightly different, but the panel came to the opposite conclusion and denied the complaint, where it was based upon common law rights that predated the registration. And in that instance, there was the complainant's predecessor in title held common law rights, which were recognized as being established before the domain name was registered. The predecessor did attempt to negotiate with the registrant to secure the domain name. Those negotiations failed. And they set up a new BC corporation, an entity that was CPR compliant, to bring the complaint and then assign the common law rights over to the new entity. And so the panel was fine with that for the purpose of the CPR, but they said that this isn't going to work for meeting the first limb of the test because the complainant, if you read the text of the policy, has to have held the rights before the registration. And the second entity, the BC corporation that was created, frankly, after the dispute really arose between the parties, simply didn't satisfy that. And the panel was a 3-member panel chaired by, in fact, our current Minister of Justice and Attorney General, the Honorable David Lametti. And that panel found that it was just no dice. This was basically trying to do indirectly what the policy does not allow you to do directly. So there's diverging opinions on that, and I'll leave it at that, since I don't want to pronounce on it one way or the other. It's just these matters do come up in proceedings.
Yeah, that's really interesting what both of you said there. Just to wrap up this topic, yeah, I think that James has hit it on the head. It's never really happened that I know of. It's rare, but I do think you should be able, as a foreign complainant, to start a CDRP even when the trademarks don't match, as long as they're confusing, because you say, hey, I've got a trademark, which gives me standing, and now I'm going to prove confusion. And that 1.4 with the unless language, that's critical. But the fundamental problem there is when you win, you don't get the domain because you don't meet the presence requirements for ownership. So in the Skechers type case that Georgina was mentioning, you've got a US owner, Skechers Corp US, but they already have a Canadian subsidiary, Skechers Canada, that kind of operates the Canadian stores. So if you're in a complainant position, your best option is to get a co-complainant. That's your licensee, that's your subsidiary, that's got those presence requirements. So not only are you going to hit standing, but you're going to be able to receive the domain. That's the safest way if you can do it. But I do agree with James that I think you should have standing, but it's a little awkward to get a remedy of cancellation because then it's going to be a race to see who can pick it up. So why don't we go on to the next topic?
Maybe before we do that, I noticed that there is a question that's appeared in the chat function. The question being, can the complainant rely on Madrid international registration effective in Canada?
This is actually a good question because Barry, it goes straight to the next topic. So maybe we'll introduce that and then I'll just answer the question to lead off.
Well, I'm sorry, there was also another question. If the domain is canceled, and it's a comment. If the domain's canceled and there's a high interest in the domain, it's unlikely the complainant would be able to register the domains, as there is some competition going after domains being deleted.
That's a good point.
A comment.
If you go for a cancellation, yep, you better watch out.
It's up for
better,
grabs.
better to get a transfer.
Right.
But why don't we go to that that other question? It's a great question on Madrid. So the next topic we're going to
Sure.
talk about is just relevant dates. Let's just talk about relevant dates, and we're talking about rights here. So let's talk about this Madrid question. Is a Madrid filing effective in Canada? Well, the answer is pretty much no for .ca. UDRP, maybe that's helpful, but let's talk about the CDRP for Canadian domains. So fundamentally, you need to establish rights that predate the registration date of the domain name. And for a .ca, those have to be Canadian rights. So a trademark application is not Canadian rights. They're not really worth anything in Canada. What you really need is you need use of the trademark, which is defined in the Trademarks Act, you know, a sale of the goods bearing the mark or advertising, or you need some sort of at least cross-border reputation. And there's some common law cases like Orkin Pest Control to establish rights, or alternatively, you need a registration in hand. So a Madrid filing, unless it's actually entered Canada and issued, doesn't start the clock. And so a big problem for foreign entities is let's say you're a German company, you come up with a new brand, you publicize it, you get your Madrid filing in just before, you've got that rolling into 30 different countries, including Canada. A year and a half later, it issues. But if someone registered the domain name in the intervening period before it issued, you may not have a remedy to go get it back, because if you don't have use in Canada, your registration date postdates the domain name and you can't anchor rights. The best approach for brand owners is to secure .ca domain names as they launch the brand in a defensive manner. If they don't meet the presence requirements, there are ways to address that, like incorporating a shell company in Canada or something like that, or finding a business partner. And now I just want to look at the UDRP for a second. And the UDRP, it's the same general rule. You have to have rights as a general rule before the domain was registered. If the domain was registered sitting around for 9 years and then you develop a famous brand, tough beans. I mean, they were there first. You can't like infringe or have a bad faith for something that comes later. That's the general principle. The difference there is you don't have to worry about Canada. Your rights could be anywhere. And in some countries, filing a trademark might actually get you rights under a UDRP, because you're looking at global kind of situation. The only exception I'd say people should keep in mind is every time a domain name transfers, you might be resetting the registration date for the domain name. So if you have rights that don't go all the way back to the beginning, but there's arm's length transfers between third parties, you could still establish bad faith potentially. That might not apply if it's just going back and forth between affiliates or sister companies. So anyway, those are my comments on the timings of the rights. I don't know, James or Georgina, if you want to jump in on that.
The only thing I'll add to that, Daniel, and it goes to your first point about, the Orkin type, reputation type use. In fact, in the ASOS case, the panel did recognize that the international use and advertising of the services into Canada were sufficient for the purpose of meeting the requirements of establishing a mark. And the panel, in fact, referred directly to federal court jurisprudence on that point, which you don't always see, but is certainly open to the panel to do. You'll note that the rules say that the applicable law is the federal law of Canada and the law of Ontario, unless there's an unless the parties select a different provincial law. But in this instance, it would be the federal law of Canada. And so I think the federal court's jurisprudence is certainly persuasive on this, that what constitutes use of a service versus use of goods And panels are likely to take that sort of thing into account, in particular if it's been submitted by the parties.
Yeah, and I'll just make one other comment there. Let's say you're a foreign company and you don't have your Canadian registration. You can't start a CDRP. But it doesn't mean if you're using your mark, you still have the better rights. You have those common law rights that James just said. So you can just wait until your trademark issues and then bring the CDRP, even if it's 2 years later. And I did this in a case, like it was a New York restaurant called Momofuku. There's one in Toronto. They launched, someone registered it, but we just had to delay the CDRP until the rights crystallized in Canada. And there's a new process that's been around about a year that you can accelerate examination when you have like a potential court dispute. And I have requested accelerated examination with affidavit support for the purposes of bringing a CDRP faster, and that has been granted. So that's a tip that people might want to try if you're on the brand holder side and you're rushing to get your trademark through to deal with some active infringements.
And the typical, are we correct in assuming that the typical timeline today for the registration of a trademark is about 2 years?
Yeah, if you choose your goods and services from the manual, you're looking at around 2 years.
Right. So pretty long time.
Yep.
Which is why then I'm going to segue now us into common law trademark rights and unregistered rights as a basis upon which to advance your UDRP or your CDRP complaint. So in the very, very opening segue, I mentioned that the first prong of the 3-part test in the CDRP and the UDRP proceeding is whether the registrant's domain name is identical or confusingly similar to a mark in which the complainant has rights. And so the first question to be answered is, what constitutes rights in a mark? And it's well recognized under both the UDRP and the CIRA policy that complainants will have satisfied the requirement for rights in a mark if the complainant owns either a registered trademark or an unregistered or common law trademark on which it can rely. And registration provides proof of trademark ownership and a presumption of validity unless proven otherwise. So as a consequence, the evidence a complainant needs to advance in support of the establishment of its rights in a mark is satisfied by proof of a valid registration. But if the complainant is relying on common law trademark rights, the complainant must advance strong evidence that its mark is distinctive and has acquired distinctiveness such that consumers associate the unregistered trademark with the owner's goods and services. So the UDRP and the CDRP panels generally take this requirement seriously and will closely examine the type and volume of evidence submitted on this point. And superficial evidence or conclusory allegations, statements, won't be sufficient to succeed under the dispute policies. So I wanted to just speak for a minute about the type of evidence, the kind of evidence that a complainant needs to submit to establish common law trademark rights for the purposes of a UDRP or CDRP for that matter proceeding. And point out that the UDRP consensus view of the type of evidence to be submitted includes evidence of the duration and nature of use of the mark, the amount of sales under the mark, the nature and extent of advertising using the mark, the degree of actual public recognition, consumer surveys, evidence that the respondent has been targeting the complainant's mark, evidence of that nature. I also want to point out just this reference to the notion of the fact that the UDRP has a consensus. So by that, I'm referring to the WIPO overview of the WIPO panel views on selected UDRP questions, the 3rd edition. It's a good source for those looking to get an understanding of case law relevant to a particular topic or issue or element of the test. It's organized in a meaningful way and it's helpful. It's not binding precedent. There is no binding precedent per se, but it gives you an understanding of cases that have been decided, persuasive cases, or, I don't think they're typically outliers, but cases that have been decided in particular areas. So when we're talking about the type of evidence that a complainant should submit, that is an area that you can look to for guidance in terms of the nature of that evidence. Now, I found it interesting that in the last 6 weeks alone, like in September and October, there have been at least 3 CIDRC decisions in which a complainant has asserted and relied on its common law trademark rights. One of the cases is ycd.ca, another is leolist.app, and the third is oakmaritimeinc.com. Time doesn't permit us to get into the weeds on each of these cases, but we will provide you at the end of the seminar with a link to the citations. And as I said, all cases can be found on the CIDRC website in any event. But I found it interesting that we're discussing this topic, and September 15th, September 19th, and October 4th, we have 3 very current decisions in which the panels who determine the cases considered this very element of what is the evidence needed to establish common law rights. So in each of these cases, the claimants did not have a registered trademark to rely on, and the panels considered whether the marks at issue rose to the level of an unregistered trademark. And in so doing, each panel considered the evidence submitted and whether the evidence was sufficient to establish these common law rights. In the leolist.app case, there's a nice section in the case where the panelist directs you and quotes from section 1.3 of the WIPO overview, which I've just read to you, recites that range of factors, and then most instructively, to my mind, provides instruction on the sufficiency of the evidence you need to address this point. And the panel, and I'm going to quote, says, specific evidence supporting assertions of acquired distinctiveness should be included in the complaint. Conclusory allegations of unregistered or common law rights, even if undisputed in the particular UDRP case, would not normally suffice to show secondary meaning. And then the panel also stated, which goes back to some of our earlier discussion respecting the jurisdiction in which you're asserting your rights. The panel stated, the fact that the secondary meaning may only exist in a particular geographical area or market niche does not preclude the complainant from establishing trademark rights, and as a result, in some cases, standing under the UDRP. So it's an instructive case. It goes through the evidence. It actually lists the evidence in the decision that the panel relied upon in arriving at its decision in favor of the complainant having established its common law rights into the trademark. The other case I'm just going to hit on briefly is the oakmaritime.com case, decided shortly thereafter. And in that case, the complainant was also able to establish it had unregistered rights or common law rights in the Oak Maritime trademark, but not in the first go round. So in that case, notwithstanding that evidence and affidavit evidence had been proffered by the complainant, the panel found that it was insufficient and actually recognized that a statement was made in support of those rights, but insufficient evidence had been brought forward in support of those rights. So They issued a procedural order, which the panel is at liberty to do under, paragraph 11.1 of the CIRA resolution rules, and basically said in this procedural order, the complainant has asserted, without properly documenting its assertion, that it relies on common law rights in an established trade name and trademark, and accordingly requested that the complainant submit documents and information deemed useful to show common law rights to the Oak Maritime trademark. So in that case, the second time was the charm. Following receipt of the procedural order, a very robust affidavit was delivered with many, many exhibits, all speaking to the extensive use and sufficient to satisfy the panel to ultimately yield a favorable decision for the complainant. So if you're in the space of trying to establish your common law rights, and if you are looking for some guidance on the nature of the evidence that the courts are looking to in that regard, then I think you'll find those three cases instructive, and I would suggest that you review them with a view to ensuring that your evidence is not conclusory, but actually supports the position that the complainant is looking to put forward. I also wanted to speak to the notion of the evidentiary threshold when the mark is, super well known or famous, as opposed to when it's a little bit more generic and less well known. And in that regard, I would suggest to you that if you're dealing with a descriptive or not inherently distinctive mark, you may be faced with an even greater onus to demonstrate your acquired distinctiveness. So let's not forget that, affidavit evidence might be key here, as opposed to, just statements. And I want to pass it over to my Daniel or James to provide their additional insight on this point.
Yeah, I've done about 5 or 10 common law arguments, and it's exactly what Georgina said there. If your mark is really unique, like if your company launched, I don't know, Google, but it's in the early stages, or it's some new company, but has almost like a coined name, even if it's only 6 months old, but it's an app and it's been downloaded 5,000-10,000 times, you can still, you probably won't need tons of evidence. You can simply say, hey, we don't have a registration yet. We've just filed, but we've been using it for 6 months. We've got 10,000 users. It's a totally made up name. And provided you got some bad faith, let's say there's a pattern of conduct where the person has registered many brands, it's going to work because they'll see that you're a real company with a real website with 10,000 downloads in Canada that predate the domain name. However, the moment that you have a descriptive word, the panel would naturally be reticent, and James and I are both panelists, to just say, oh yeah, you've got these rights. You're going to have to put your money where your mouth is with real robust evidence, maybe in an affidavit. I remember that was the case for me in one of the first cases on this, because they only amended the policy to allow common law rights in 2011. And at that time, I did a case to recover the domain name Guitar Center. Now, Guitar Center, for a store that sells guitars, you could easily argue that's descriptive. And so we took a lot of effort to explain that it's the largest musical instrument dealer in the world. It has 174 stores, $1 billion of annual sales. They're advertising on the radio. They didn't have any stores in Canada, but they were well known, just like Dunkin' Donuts is well known in Canada, or other brands that you might not see here. And again, it helped that that owner of that domain name had his own musical instrument shop with its own name, And he had 3 different names of famous musical instrument competitors, Guitar Center and 2 others. So it's kind of obvious that he was grabbing it just to have, all the top .ca musical instrument retailer names they feed into his website. There was some clear bad faith, and the common law rights worked. So I think you want to scale your evidence with the distinctiveness of your name in some way.
Yeah, I'll just add a couple comments there. First of all, I agree with everything that's been said so far. One question that I often get is, when do I need an affidavit? When is it okay for me to just attach documents? When do you need an affidavit? Because the rules don't provide really any guidance on this. The rules of evidence that apply in court simply don't apply. So it's very relaxed in that regard. But I think kind of in line with what Georgina and Daniel have said, the extent to which you're asking the panel to rely on statements rather than independent third party, verifiable data, like for instance Google Analytics or things that can be tracked down on the web, I think that militates more in favor of putting in an affidavit. It's a sworn statement. It's something that in principle could be used against you in another proceeding. And so if I see an affidavit, I see, okay, well, these people are taking this a little bit more seriously. That doesn't mean you can say whatever you want in an affidavit and expect the panelists to find for you, but you want to calibrate whether you need an affidavit or not on the basis of the strength of the independent third-party evidence you can put forward. I don't need you to attach Google Analytics to an affidavit. If you show me a printout of Google and it's looks colorably like a Google Analytics page and not something that somebody created in Paint, then I think we're going to be okay. But that's one thing. And the other is, as far as the volume or quality or quantity of evidence that you need, I think, in my experience, both as counsel and as a panelist, it's not quite as exacting as trying to make out a passing off claim in court, in the federal court, for instance. I don't think, the hidden bench decision that a lot of people are aware of is going to be the standard in domain name cases. I think it's a little bit more permissive than that, in particular if it's not very, very descriptive, the mark on which you're relying. But frankly, even if it is, I don't see panelists requiring the level of evidence that perhaps the courts might in similar circumstances. But, I advise my clients, you err on the side of caution, err on the side of too much rather than not enough, because you don't want to throw good money after bad and do this, for nothing.
Yep.
We have a question in the chat about whether we'll be distributing links to the cases that have been referred to, especially Georgina just referred to a number of important cases or decisions. And yes, after this presentation today, we will endeavor to send an email around to people who have provided those email addresses to us with links to the cases referred to.
I also see another question, Barry.
Yes, I saw that. We do tweet out whenever there's a new decision. We do send out on Twitter, but I understand not everyone is glued to their Twitter feed, unlike a former US president. I guess he's not on Twitter anymore, at least for now. So we are looking at putting together a monthly newsletter as well, called or if you're signed up to receive our fresh decisions through our website. So again, take the time to look for that feature on our website at ciidrc.org, and you can look forward to receiving a monthly update.
And Barry, just in line with that, I was just thinking, in preparing for this panel, we had a discussion a few days ago, and Daniel and Georgina and I were commiserating that there's no Canly or really, really good searching database that you can use to search for these decisions. And so I think there may be a coalition of the willing forming that might be interested in kind of getting behind that and creating a much more searchable database, so that you don't necessarily only have to rely on, for instance, the WIPO overview, which I agree is a great source, but it's a little cherry picked, and it's also UDRP, not CDRP. It would be nice to have more search functionality, and I think that's something that's, stay tuned. I'll just leave it at that.
Yeah, there's one other question here.
We recognize that, and we're looking to see if we can make some further technical updates to our website to make decisions searchable like that.
Well, just a bit of a short plug, not a big plug, but your decisions online are available. They come out in pretty much real time, I think. And although there isn't a descriptor as to what the case is about, it's just transferred or denied. If you get into the case, there is a searchable function, which is helpful. The problem is you don't know which case to start searching. But if you do it by order, it is there, and the website is a great resource. It also has all of the rules and the policies as well as the cases. So it is a great first resource. But yeah, totally in line with James's and Daniel's commisery on the searchability generally of finding relevant case law.
Someone else here is asking about Canadian trademark law, and does it include formal declarations of acquired distinctiveness? So yes and no, it does, in that if you apply for a non-distinctive trademark, you may convince the examiner through affidavit evidence that you have sufficient use and reputation such that you've achieved acquired distinctiveness, and then you will receive a registered trademark. And then that has the same power and authority as any other registered trademark. It's presumed valid, it's enforceable. So that's one way to get a form of declaration. In addition, a court in a passing off case or similar can say, yeah, you've established acquired distinctiveness. And then, I mean, that's going to be enforceable and probably respected by other courts as well. So that's pretty much what we have. But I do recall that some countries have different kind of declaration, or they even have like you can get declarations of the mark as famous. So we don't have like that, you know, mark is like, you know, famous, you know, certified famous or certified distinctive, other than the process we have to prove distinctiveness before an examiner.
Thank you for those comments. Just noting the time, we have about 12 or 13 minutes left, and still a few other topics to get through on our agenda if we can. So maybe we'll just return to the agenda for now and see if we can make further progress.
I guess we'll jump into the fourth topic then.
Yep.
Sure.
James, are you starting on that? Or which, my case is long, but I could try to be brief, or maybe James, you want to go first? And
Sure. Okay. Yeah. So we were going to talk about a couple notable recent decisions, and the one that I selected is because you have a sea of transfer, see the occasional denied, and those are the ones I click on because I find them to be the most interesting. See, you know, why were they denied? And I'm going to talk a little bit about the Boost Collective case, which is one of the more recent ones that came out a couple months ago, I believe. And it was, the domain name was boostcollective.com. It was a UDRP case. The domain name was registered in 2015. And the complainant applied for a trademark, USPTO trademark, in August 2019, proceeded to registration in April 2020, tried to negotiate the domain name away from the registrant. Negotiations obviously didn't prevail. And they decided to, the complainant did decide to commence a complaint. And although the panel found that the marks were confusing, the mark and the domain name were confusingly similar, they're in fact identical, the panel found that the registrant had a legitimate interest in the domain because it was advertising and ostensibly selling the services were marketing and online engagement services. And there was evidently some evidence of that. And it seems that the registration of the domain name, which was actually being used, it wasn't simply parked, predated the trademark and predated even the incorporation of the complainant's business by 3.5 years. And so this is one of those rare cases in which the panel, in fact, found that this is an abusive process and made a finding of reverse domain name hijacking, which is a concept under the UDRP. It doesn't really have any teeth. There's no consequences to it. There's no, cost awards or damages or anything of that sort. But the tribunal can basically declare the complainant basically a vexatious complainant in that particular instance and make a finding of reverse domain name hijacking. The CDRP contains a similar provision is, bad faith complaints. And what's interesting is there, the panel can determine, if they determine on the balance of probability that the complainant was acting in bad faith, which is a bit of a fluid concept, in particular, whether you're in a common law or civil law jurisdiction could change. It can actually order damages, or pardon me, costs against the complainant up to $5,000, which are to be paid to the provider in trust for the respondent. And the complainant cannot start any other proceedings with that provider or any other CERA provider until the cost award is paid. So it's actually, there's a little bit more, it's a little bit toothier than the UDRP. I'm not aware of any bad faith registration cases. I confess I haven't systematically searched them all. Something we can maybe do with our new tool, but I don't know of any of those cases. But there are a couple reverse domain name hijacking cases, and again, in this one, in the Boost Collective, they said, look, this is a Plan B type situation. That's how the panelists framed it. You tried to get the domain name, you didn't have pre-existing rights, then you decided to issue a complaint. In this instance, the respondent said, no dice, I'm going to actually, defend this, and succeeded. And so it just goes to show that even though statistically the overwhelming majority of complaints do succeed, in particular ones that are undefended, if you're a registrant or a respondent in the parlance of the UDRP and you have a legitimate interest, it is worth responding to the complaint and putting that forward. In this instance, I don't have a great grip on the depth of evidence that was provided. It's not that clear from the decision, but evidently it was enough to convince this panelist. And frankly, if you're showing that I use a domain name for something, screenshots of it and dates, maybe with using the Wayback Machine, showing that it's, it wasn't just yesterday that the content was there, may well be enough. And it certainly seemed to be in this case.
I find that really interesting, James, and I'm sort of struck by the notion that the only monetary sanction that exists in the context of any of these proceedings is with respect to this CDRP rule dealing with bad faith, and that there's no equivalent provision or no ability to order costs in favor of an aggrieved complainant who also has incurred costs associated with protecting its rights as against a rogue registrant.
Yeah, it's not something I've spent an awful lot of time thinking about, but I suspect the reason is that, look, these are fairly informal proceedings. Not to denigrate myself or any of my co-panelists, but it's not like you have to demonstrate, ridiculous credentials to become a panelist. You certainly don't have to. It's not as hard as becoming a judge. So, we're not appointed by order in council, so it's not quite as rigorous of a process. Panelists also tend to be, trademark lawyers, people who act for complainants in their counsel life, and so it seems to me that restricting the authority to transfer and or cancel is maybe just a bit of a check on what would otherwise be rather significant authority in a pretty expedited administrative proceeding. That's just a thought, though.
Okay, maybe I'll bang off a recent case because I can do it in about 30 seconds. I guess it was just a reminder. It was a very simple case, but the person defended it all the way, and there was a whole bunch of replies and nonsense. So the case was nalgene.ca, and the principle is very simple. It's extremely difficult to register a domain name that just exactly matches a registered trademark unless you can show legitimate interest. It's essentially automatically bad faith. So, of course, if you've got trademark rights, like we've all heard of the Budweiser in Czech Republic and the Budweiser in United States, they could both go for it. Or if it was your last name, or if you were in a commercial agreement and you had an exclusive distribution rights and you got it, maybe it falls out after, those are the kind of legitimate bases to get it. But just because you're let's say a fan of the company, I did this case once with Sega.games. He said, well, I like Sega. It didn't work. They're like, you can't just go out and get, Xbox or Sega and you don't have some alternate legitimate purpose. And with Nalgene, the person said, well, I've been selling Nalgene bottles for 20 years. And I just want the domain name to bring people to the website. But unfortunately, he had a general merchandise camping store and sold hundreds of products. And he had about 20 domain names of different brand owners. And he's just really just trying to boost traffic by registering a bunch of people's famous trademarks and bringing them to, Joe's Camping. And that doesn't really work. So that's the reminder. It's incredibly difficult to just take an exact match trademark unless you can positively prove some sort of good faith or legitimate interest. And a lot of people don't realize that. They think just because they're an actual customer, that if it's available, they should just be able to take it. And that's usually not the case. Georgina, I'll pass it to you.
Oh, gosh. So I don't know how much time is left. And the case I decided to cite is about 42 pages. But
We have about 4 minutes.
let's go. Okay. The case that I was going to summarize for you, and you'll get the link as well, referred to earlier, is the YCD.ca. So before we even begin, I challenge each of you to think in your mind whether YCD to you denotes anything more than sort of a random 3-letter acronym, or whether it's just what it conjures up in your mind. Because when I first heard the acronym, it didn't lead me anywhere in particular. But in this particular case, the complainant was the Nanaimo Airport Commission, and the registrant, this Chris Stewart, purchased the disputed domain name YCD.ca at an auction in 2013. The complainant and the registrant had subsequently engaged in negotiations for the sale of the disputed domain name. The registrant asserted essentially that his buying and keeping and offering the domain name for sale had nothing at all to do with any improper purpose. The YCD is the 3-letter IATA acronym for the airport in Nanaimo. So for those of us in Toronto or in Edmonton, there's YYG or YVT Vancouver, I think. It actually was the domain name associated with an airport in Nanaimo. So this case is great because, number one, it speaks to the elements of common law trademarks. But the focus of this case is in respect of bad faith. And the registrant's basic position was he runs a legitimate business. He invests in domain names, which he uses for, a legitimate business he had of like printing and design. He bought the domain name YCD as an investment and for a personal venture. He only buys generic names, largely acronyms for investment, and he has no obligation to develop the website. There's nothing wrong with purchasing this domain for investment purposes. And I'm really not doing justice to this case, but the determining, lawyers, every case turns on its facts. The fact in this case that really swayed the panel to find that the registrant was acting in bad faith, which is what they found, was evidence from the Wayback Machine, which established that or showed that in 2014, so way back, the YCD.ca domain carried depictions of an airliner taking off and landing and the words arrival and departures. So the panel did a lot of inferring of the facts arising from the evidence, and basically concluded that the banners on the web page did not support the registrant's position that he had no knowledge that this was a generic acronym, that he had no knowledge of the fact that it was a trademark that belonged or was associated with an airport, and found bad faith. So it's interesting because on first blush, it may be that the acronym is or appears somewhat generic, but the evidence proffered by the complainant was persuasive, and it was difficult for the registrant to get around the fact that the visuals on this dormant site, effectively dormant site, actually had an airplane and a reference to arrivals and departures. Did I totally butcher that, gentlemen?
So a thumbs up from Daniel.
Okay.
I was one of the panelists, so I have absolutely no comment.
If you're gonna register a domain name that's an airport code, don't show a plane taking off and landing. That's the take home.
That's the takeaway.
Kind of looks
That's-
like you're going for that angle.
That's the takeoff. From the
It's a little suspicious, yes. Well, everyone, it's hard to believe, but we've gone through an hour. It went by very quickly. I want to thank all of you for your contributions, and we've had some positive comments already in the chat about the quality of the discussion and explanation. There's always more that can be talked about. There's many complexities and layers to these cases, but that will be for another time. We'll do this again, and we'll reach out to everyone and let you know the next time we schedule a webinar. In the meantime, stay tuned. Oh, I want to just thank behind the scenes. You may have caught a glimpse of her early on the video. Ina Ergashiva, our deputy director. She's been working the controls, and she's the mastermind behind the scenes. So I want to just acknowledge and thank her help here today. And again, for all of you, hope you have a great rest of your day, and look forward to the links that will be coming to an email near you soon. And if you're in British Columbia, I believe after a day or two, you'll be able to go online and register 1 hour of CPD credit towards your yearly obligation to the Law Society. And with that, again, I'd like to thank everyone and wish you all the best. Thank you very much.
Thank you.
Thank you very much.
Take care,
Bye-bye.
everyone.